I'm going to introduce the speakers, and I'm going to quickly read their bios as well. So we've got a number of folks with us here today. First is Mike Jordan. He's the Director of Government Relations from Saskatoon. He's been with in that position actually for the last 6 years, working with the City Solicitor and the City Clerk, and has been extensively involved within the modernization and updating of the City of Saskatoon's governance model. And that includes City Council's policy on decision-making procedures and processes. He has an extensive and detailed understanding of the Council structures, decision-making process in several jurisdictions across Canada. Prior to that position, Mike was employed with the City of Calgary in the Government Relations and Public Policy Consultant. So Mike comes to us with a tremendous amount of experience and knowledge, so I'm happy to have him here. Phil Boivin, what do I say? Boivin, okay, see, several of my colleagues said you got to say it with a French accent, and the best I could come up with sounded a little bit more like Jamaican, so I'll do the best I can, so yeah, I'm on. So Phil worked in the Urban Municipal Administrator for 22 years before joining the Ministry of Government Relations in 2002. He holds a Class A certificate issued by the Urban Board of Examiners and has completed both levels of the National Advanced Certificate in Local Authority Administration. So again, we're going to hear from Phil as well. Melissa McCloy is a municipal advisor. She is the newest member to the Government Relations team and has worked at the Urban and Rural Administrator prior to coming to the ministry. Of course, you all know Laurent Mougeot, who has a tremendous amount of experience, been working with municipal government since 1976. So I'm trying to remember what I was doing in 1976. We had that question earlier, what you're up to, and most of mine was no good at 9 years old, 1976. So these days, Laurent's focus is mainly on promoting and defending the interests of local governments, and of course, heading up a team of very passionate individuals who have made this experience here at SUMA a fantastic one so far. So a quick round of applause for all the staff and all the hard work they've done. That includes you as well, Laurent. Well done. Good job. Good leadership. Stephen Dribnenki is going to round out our panel this afternoon. And Stephen's come to SUMA as a policy and legal advisor in January 2014, and it quickly took on a number of major responsibilities from the policy and advocacy on the environment, intergovernment affairs, and all those various files within SUMA's legal services. So I'm not going to go into too much more from there because I want you to hear from those folks. So I'm going to go ahead and turn the floor over.
I'll take it over from here. Laurent Mougeot, I'm the Chief Executive Officer with SUMA. Had a chance over the years to work in northern Saskatchewan, worked in Sandy Bay, Pelican Narrows, Beauval. Also did some work on Laurent for a while. And then worked with two rural municipalities, Prince Albert, number 461, Buckland, number 491, and the city of Prince Albert. Then progressed with the City of Prince Albert as Senior Planner, Director of Corporate, what was it called? Corporate Communication and Human Resource, and then ultimately Acting City Manager. So my experience is in those three different sectors, the north, rural, and urban, medium-sized city. And I guess the intent today with all of the speakers is to invite you to the microphone and throw questions or a bit of advice that you're looking for, lessons learned that you want to share with your colleagues. And our goal is to make it as interactive as we can with you today. So, Stephen?
It's actually an absolute pleasure to be here, and I'm very honored to be with, I think, a great set of folks here. I think that they bring a lot of experience, and I'm just honored to have been invited to take part and be here. Since starting in January 2014, it's been a pleasure to take on the various, not only the policy tasks, but also take on legal requests, which of course, I think that not only do I get to have the insight of what some of the issues are that are facing people from time to time, but also see emerging trends, and then try to let you know through Legal Voice and the SUMA Urban Voice magazine about issues that might be facing your communities. At the same time too, you know, even if sometimes an answer is not easy to find, and I apologize if ever at any point in time it takes me a little while to get back to you, but at the same time too, it's always a very, very rewarding situation for me to get those questions and see what's going on. I think that I also would like to thank as well all the folks at municipal affairs as well, because I know that they play an important role, and all the staff at each one of the municipalities, because it's a awful taxing work at certain times when you get some of these intractable problems and just looking for a solution. So actually with that, if there's no questions, how about Phil?
Sure. For those of you who may not know exactly what Advisory Services and Municipal Relations Branch is all about, we are the branch of government relations that provide people with technical advice and answers on legislation. Primarily, we will speak with your administrator and go through a variety of functions or a variety of discussions, from tax enforcement to elections to passing bylaws or resolutions as they may come by. We also have discussions from time to time with members of council who quite often are struggling with various issues that are facing their municipality. We don't always provide an answer that they might hope to hear, but we do try and come up with some helpful advice. We also receive probably around, I'd say 25% of our calls come from citizens and ratepayers. And they've typically got questions from about their municipal council. Whether it's they're starting to take action to enforce taxes. Are they doing it properly? They're after me because my dog is running at large, or because my property is a bit of a mess. Can they actually do some of these things? And so we'll walk through that process with them. From time to time, they don't like a decision of council, so we do talk to them about the things that they can do, along with other citizens, about how to approach you as members of council, as decision makers, to see if the policy that has been implemented is the correct one for your municipality, or whether there are some alternatives that should be explored. So that's kind of what we're all about.
Excellent. Thanks, Phil. Let's turn the table back over to Melissa then for an introduction, and then we'll wrap it up with Mike. Just a couple words.
Well, I think Phil has covered off what Advisory Services offers as a service. I think the only thing that I would add is, if you have questions or concerns, do give us a call. We do enjoy helping municipalities to overcome some of the difficulties that they face.
Great. Thanks, Melissa. Mike.
Thank you, Councillor Murray, and thanks everyone for inviting me on the panel. My sort of expertise is really around city governance and so on. And we've been at Saskatoon City Council. I got to give our council a big credit for taking the chance to sort of update and modernize their governance principles. We've come a long way since about 2014. Made major changes to all our procedures, committee structure, council decision-making structures. So that's working fairly well. We make changes as we go along, but for the most part, I think we've presented them with some good options, and they made some good some recommendations for moving forward. So I think they're in a good spot right now. I think we've pretty much got to a good point where we won't make any major changes for a while, and then proceed from there. So it's it was a daunting task to come up with a bunch of research on where we should take it, but I think we're in a good spot now where we can start making really solid decisions with the right information.
Thanks very much, Mike. So that gives you an idea of the quality and caliber of people you have up before you here on the panel. So I encourage folks to please make their way up to the mics for any questions you might have. There are no bad ones. There's probably a bunch of really good questions out there. So feel free to work your way up to a mic. I'll have you introduce yourself and what community you're from. Microphone 1. Yes, go ahead.
Hi, Tina Cresswell, Maple Creek. Steve, we several of our council attended the session on conflict yesterday, and there seem to be disparate views on what we have to do when we declare a conflict in a meeting after we've filled out our disclosure statements. I think the first speaker said that we had to fill out new disclosure statements, but the second speaker said we had to then just amend our disclosure statements if it was a conflict that had not been disclosed before or it was new. I wonder if maybe the first one was a recommendation, the second one was absolutely what was put into law, and can you comment on that, please?
Well, why not? I guess from my take on it, and thank goodness we have some provincial municipal affairs advisors here too, and you can correct me if I'm wrong, but my understanding would be that you have the existing form, and that it could be simply amended to add, or would that be the sort of view that you would take, Phil?
Sure. The template that was forwarded to all municipalities included 3 forms, Form 1, 2, and 3. Form 1 is the initial public disclosure statement. And that would be the form that all of you would be looking at this point in time. And that's where you disclose your employer, your controlling interest in corporations, your property holdings, and so on and so forth. If at a later date something changes, or where you declare a conflict of interest that is not already reflected on your Form 1, then what you would get from the administrator is Form 3, which is a direction to the administrator to make an amendment to that public disclosure form that you have. Once the Form 1 has been filed with the administrator, my read of the legislation says that it is only the administrator that can make that change to the form. In addition to that Form 3, not so much this year because it's the year of a general election, everyone will have to resubmit a Form 1. But next November and the following Novembers thereafter, members of council would be completing Form 2, which is an affirmation that there's no change to the Form 1 or that there is some type of change, and you indicate on there what that change was. Perhaps you have a new employer, and the administrator will then make the appropriate change. Does that answer your question?
Yes, thank you.
Thanks very much. We've got somebody at number 3, microphone 3.
Corbin Meyer, Town of Langham. Just wanted to take an opportunity and ask you, we have a situation right now with an arena board. Unfortunately, I'm fairly new to council. Unfortunately, at this time, the arena board is not governed by any formal policy, and yet they have their own. They spend money and make decisions, but unfortunately, they've become dysfunctional to the point where we kind of feel they need to be moved and replaced. And I'm wondering. Very early stages of discussions on that. I'm wondering if any of you have had any experiences with a situation like that, or is there any known process for accomplishing that? Or
Thanks very much for the question. I'm going to go to Laurent Mougeot.
Maybe I'll start with some general comments, and then we could go to the municipal advisors for that. But I have seen over the province a number of these rec boards, and they're structured in all kinds of different ways. Some of them are formalized, they're incorporated, they have bylaws. Some of them are actually committees created by council members or by council. Other ones are a composition of representatives from different municipalities. So at the outset, we need to acknowledge what type of board that we're working with. Are they really formal? Are there a bunch of volunteers who've spent a lot of hard time working to keep the arena going or the programs? But ultimately, the first question is, are they structured through council? Are they structured on their own? Are they informal? And if they are informal, it's quite possible that they don't have any bylaws or governance system to keep them going, and that there's no provision to address vacancies or lack of activity. For example, if you are incorporated, there are meetings to be held, there are positions to be filled, there are reports to be issued, like financial statements. So the composition of the board is where the first question should be, is how was this group formed, and are they operating according to the bylaws and the rules? But I'll turn it over to the municipal advisors for further comments.
Listen, Bill.
Thank you, Laurent. As Laurent mentioned, most of the boards, particularly in smaller communities, are created by council. And in many cases, there should have been a bylaw. That may be quite some time ago. And what happens sometimes over time is that these organizations will take on a bit of life of their own. And for a while, that's fine, because you know what they're doing, it's maybe not quite what council wants, but then all of a sudden the straw breaks the back. And so we've got an organization that has drifted. It's like a child that's kind of moved away and all of a sudden become very undisciplined. So the remedy is going to be pretty fierce, particularly in smaller communities where everyone knows one another. But I guess the arena board probably has the arena's interest at its heart. The arena is one part of the community, and what council's job is going to be is to try and blend the two. Trying to make the folks on the arena know they're part of the community and they still have to meet the overall objectives. Now, a couple of things. First of all, when they're spending money, under the generally accepted accounting principles for public sector bodies, this is all supposed to be part and parcel of the municipal financial statement. So it needs to be drawn in there. And certainly as part of that, there should be some dialogue between the board and council. Council should know what the board is doing. Council should also have some input into the direction for the board. But again, if things have been allowed to continue in a certain direction, it's going to be hard to turn this a little bit. The one last comment I want to make is that the council procedures bylaw, which is now a mandatory requirement for all municipalities, also requires council to establish the meeting procedures for its committees. It can certainly allow the committees to create those procedures on its own, but the procedures must be in writing and they must be publicly accessible. So I guess in a nutshell, it's going to be council and the arena board sitting down, figuring out where going back to that original bylaw, where have we drifted from that? And how do we, what's our new direction? So possibly a strategic planning session, something along that line may be beneficial.
So just to further the question, in the event that communication breaks down or has already broken down, or there may even be an absence of a bylaw to begin with, what then is council's recourse to just take some initial steps to actually setting a policy for that arena?
Okay, again, council created the board. Council's going to have the ability to reorganize it. It will have that ability unless the board is, has been organized as a nonprofit organization or a legal separate entity. But that would be a rarity in the case of boards in smaller communities.
Very much.
Great, thanks very much for the question. Microphone 1.
I guess that's me, huh?
Yes, please.
Rod Gardner of the town of Kamsack. Every spring, or I think it's in the spring, around our council table, we have the debate with publicizing the past due taxes. And I don't know whether we actually advertise them as just a point of interest for people, or if there's a legal reason that they have to be printed. Having said that, we do it every year. What our question is every year around the table that we debate is how far can we go with the description? Sometimes the administrator of the day will tell us that all you can give them is the legal description. Well, if all you're going to put out there is the legal description, nobody knows really where that is anyway, so what's the point? Then we got to addresses. Then somebody said, well, this is not a really good idea, you shouldn't be doing that. We want to put the names in too. We'd like clarification as to how far we can go. If we're going to publicize it, to let people know that they're past due taxes, why can we not put the civic address and also the name of the property owner so that everybody knows why that's in the paper to begin with?
Ms. McCloy, would you like to tackle that one?
Sure.
Thank you.
So publishing the list of lands in arrears is one step that is required within the Tax Enforcement Act. And within the Act, it does not speak to publishing the name. It only speaks to publishing the legal land description. Having said that, thinking about other legislation, in particular LaFoIP, it would most likely be a breach of that person's privacy to publish that information along with the name and the civil address.
Okay, well then, where could I go to get total clarification as to how much privacy this bad guy is entitled to? You're telling me I can put the legal description in the paper. Anybody can come into the town office and say, well, I see this legal description, I'd like to know what the civic address is. And we'd be obliged to tell him, I believe. He might even be able to say, well, who's the owner? If not, he can go online, go through ICS and find out who the legal owner is anyway. So if somebody wants to find out, they can do that. Why don't we just save people a whole bunch of trouble and put the name and address in at the same time?
Okay. The short answer on that is that the legislation doesn't expressly allow you to do that. And I'm wondering if, basically what we're looking at is some public shaming there. It's just not expressly allowed for in legislation. So I think if the council is inclined to publish the names, it may want to obtain independent legal advice.
Well, then I guess my request would be to ask SUMA to lobby the government to change the legislation, because if we're going to go to this trouble of putting in the legal address, we might as well give them the whole ball of wax.
Thanks for the comment. Number 3.
I just want to speak to your problem. I know villages and towns and cities have problems with collecting back taxes and all kinds of trying to shame somebody will not get your taxes back, will only create a problem, and that's why there's legislation where you can't shame a person. Ourselves as a resort village, being a small village, we were in that problem, and our administrator brought forward the fact that I'm not going to make an advertisement, I'm going to just tell you from my personal experience. We hired a company to collect the taxes for us, and you can legally hire these companies. It does not cost the municipality any money. What does happen though is these companies go out and they collect those taxes in arrears for you from these people, and they put the service that they charge on the taxes, which is legislation, I believe, that how they get paid. So if you're trying to do it on your own by thinking you can belittle somebody into paying their taxes, the best is just to hire a company to go ahead and do it, and they will make that person comply, or will go into process of getting that property back to the municipality so that they can sell it.
Great, thanks very much for the comment. Stephen, would you like to?
I would actually just like to add to that too. There's a lot of, the Tax Enforcement Act, I think, is kind of the go-to mechanism in a lot of different ways. For a variety of reasons, you might not want to take title to a property. And there's actually a lot of alternative forms that are allowed in the, for instance, Municipalities Act, but all municipal legislation. The gentleman just kind of identified how one of it might work. There's also, you can sue the delinquent taxpayer. You can also, there's actually a laundry list of sections as well that set up different options that might exist depending on certain circumstances. And I really encourage you to look at that too, just if there might be another opportunity for a low cost without having to take the title as well. So just to mention that as well right now.
Thanks, Stephen. Microphone 1 and then 3.
Question for you with regards to the public disclosure statement, and I've heard this just talking to numerous councillors. When the councillors fill it out or the mayor fills it out, it becomes a public document. So it's in the office, and as an administrator, do I have to give that to the public when they come in and ask, or do they have to have a specific reason or concern when they're asking to see that?
Can I get you just to introduce yourself, where you're from?
Oh, sorry, Carla Kading from the town of Churchbridge.
Thanks, Carla.
Okay. Carla, when the person comes in, they do not need to offer a reason. They have a statutory entitlement under Section 117. That's the same provision that allows people access to minutes, bylaws, and other municipal documents.
Okay. So some of the concerns that I've heard from councillors is, are they just coming in to see what I'm involved in and what business I'm involved in? They're not really there because I have a conflict, they're just being nosy.
And they are exercising their statutory right to do that.
Okay.
I'm sorry.
Yeah.
No, that's fine. That's what I understood it to be, but I just wanted to clarify.
I think that particularly in smaller communities, everybody already knows what's happening, so they actually don't need to come to your office to find out. There certainly may be some that do, but I think the council, legislatively, they cannot put up any obstacles here. The people do have a right to take a look at that if they wish.
That's what I had told my council, but I just wanted to make sure I was on the right page.
Thanks very much. Microphone
Steve,
3.
comment.
Oh, I'm sorry, Stephen. Just hold on to that.
Sorry,
first thought.
I apologize. I actually just wanted to say too, and I understand that what's going on it's a lot similar to what's in place for MLAs, where you can just go to Google and you can find whoever your MLA is and see their disclosure documents as well, so it's available to the public.
Great. Thanks, Stephen. Microphone 3.
Lori LaHoo from the Village of Loon Lake. I'm the administrator. Just have a quick question about those disclosure statements. I have a counselor who has put property of an independent son on his public disclosure, but refuses to leave the council chamber when any matters come up with this person. Because it's on his public disclosure, is it not a conflict already because he's already admitted to it?
I'm not going to speak to the specific situation, but if a person does have a conflict of interest, legislation requires them to declare the conflict and to exit the council chambers. There's going to be, certainly the council procedures bylaw can expand on that to provide members of council some clear direction as to how they can deal with that as well. In addition, the mayor, unless I'm mistaken, has the ability to question and to encourage the member to abide by the legislation. If the member chooses to not abide by the legislation, there are consequences laid out in the legislation. A person who contravenes the conflict of interest rules is deemed to be disqualified, and council has the option, the ability to take action if they deem that appropriate.
Thank you.
Thanks very much. Microphone 1 and then 4.
Pauline Chuka, Mayor of Esterhazy. On this disclosure statement, I think we just need a little bit of clarification from SUMA. Some of us are of mixed opinions and minds on this because as far as public disclosure, if we're doing this for the right reasons, we shouldn't have anything to hide anyway. But on the other hand, do we not have the right to some privacy? Because in small communities, you're right, people think they know everything about you, but they don't necessarily. My bigger concern is SUMA as an entity has spoken earlier this morning saying that this came up quite quickly and that you had the opportunity to speak and change a couple of things before this came through. And I guess my question is from you, are you honestly comfortable? Is this something that you feel we should be doing? Because if it is, then I believe that we need to take a step back and follow your lead.
Laurent?
So I will start with the response. So when SUMA was initially approached on the topic, we didn't have a lot of time to respond. And while the consultation started in May, and the legislation was finally passed on November 19th, I believe, a number of steps occurred there. Initially, the consultation was only a few days, and then we were able to get extensions along the way. I could tell you that initially the disclosure was fairly demanding on the part of the municipal elected officials. It contemplated things that if you were personally aware, and by the way, I want to be clear that this is not the way the legislation came out, but initially the expectations in the drafts were that if you had been made aware by your parents, for example, that you were to inherit the local gas stations, you would have had to disclose that as part of your public disclosure. And we took that out because that's just not reasonable. Some kids may be privileged to certain things that their parents have intended to do with their will or the estate and not have shared that with all of the siblings. So you could just imagine how, and not only that, but that goes way beyond what we've seen around. Same thing with the extended family disclosure. So over the weeks that we negotiated with the province, we were able to bring the disclosure at the same level as what is applicable to a provincial elected officials. Now, the argument could be made, well, why would we have to disclose at all? And I could tell you that we have seen over the years a number of situations where local elected officials have found themselves in situations where they should have disclosed that they were in positions of conflict, and it may not have been clear to them. So the first step was to see that the legislation has a very clear, and we're working through that right now, but has very clear expectations in terms of the disclosure. So the forms that have been provided by the ministry are attempting to provide some support with that process. So it has gone from having not to disclose much, and some municipalities, by the way, were doing it voluntarily, and the cities were, for the most part, I think all of the cities operating under the Cities Act were bound by that disclosure. So it was bringing some level playing field into the municipal sector, but also bring them to the same standard as provincial elected officials. So when you make decisions for public interest, that you're not perceived or you're not actually putting your personal interests ahead of those of the public. So that was the intent, and there's nothing wrong with that. I think the implementation of it and how it rolls out is an issue that we continue to be concerned with.
Thanks very much, Laurent. Is there anybody else want to add to that? Thank you. We're going to move to microphone number 4.
Yes, Erhard Pogemiller, Town of Robert. I happen to be the mayor of the town, and I have 2 questions. I'll ask one, and if someone else wants to take the mic, I'll wait my turn. But the first question is, yesterday we were told that if we declared a conflict of interest and left, it was recorded in the minutes. After the meeting, we were also to go to that file and record that in that file, the closure file. Now, is that right or is it wrong? Because I've been hearing 2 different things here. I don't know, maybe I'm a little slow or maybe the day is late and so on, but I need clarification on that.
Who wants to tackle that one? Do we have to go back to the document and actually note in the minutes?
The legislation actually requires that Form 3 after every declaration of a conflict of interest when at a meeting is the way that the legislation is written. But again, in most cases, it's going to be no change to your public disclosure statement. So it's going to be filling out a Form 3 saying no change required.
Thank you. Can I ask the other question in
sure.
relation?
Yeah, while you're there, sure.
As mayor of the town, then when I have a council member who I know is in conflict and doesn't declare it or leave, what is my obligation then?
I need to research the legislation on that. I did come across a provision that's required, or that there's some additional powers for a mayor. Can we get together later to take a look at that?
Sure. Thank you.
Great. Thanks very much. On to microphone 2.
Hi, Jenna Johnson from the Village of Blaye. I heard of a community or a municipality that's entering into a confidentiality agreement with a developer, and I was just wondering how that might work if it was allowed, and I guess if it was allowed, how would the municipality's responsibility to the ratepayers in general be affected then?
Laurent?
I don't think a municipality could ever contract out of its statutory obligation to do this, to make decisions in an open environment. So that's where I'm starting with that, is my understanding is you cannot contract yourself out of statutory obligations. So I'm going to turn it to Melissa or Phil from a provincial perspective, how they feel about this.
Who wants to tackle that one?
I will.
Phil, thanks.
Yep. Section 117 provides people with a statutory right of ability to inspect any contract. So even though you've, I think entering into an agreement where you want it to be confidential, you want to get legal advice on that. I don't know that that's possible.
Great, thank you. Microphone 3 and then 1.
Yeah, Dixon Bailey, Town of Oxbow. Want to go back to an earlier question about the arena, or similar related to that. We're in the process of doing some restructuring of our recreational services. Our arena is owned by the Arena Incorporated. It's a cooperative, although they didn't know that until a week ago. They'd forgotten. It was 40 years ago. But we have a swimming pool that is owned by the town, but is run by a separate committee with their separate accounts, separate books. We have ball diamonds in the same situation. We have a fire department that has its own account, which none of them really want to disclose very much. Are they all subject to town audits or the audit of the town auditor? When the fire department, for example, may buy equipment that then becomes an asset of the town, but we haven't paid for it. The swimming pool gets rebuilt, it's an asset of the town, but it's fundraising from somewhere else. And the same with the ball diamonds. Where's our responsibility and liability?
Like to tackle that. Phil?
Sure. You are going to have a discussion with your auditor. As I mentioned, the generally accepted accounting or auditing principles for public sector bodies looks at the municipality as a whole. And we then have to have those discussions with those volunteers. Volunteers are very important to municipalities. We don't survive without them. But yet, it's a matter of conveying to them that they are part of a larger organization and that they're not separate. They are part of that larger organization. So you want to have that discussion with the auditor and then with the volunteers that you guys are in that together.
Thanks, Phil. Stephen, you had something?
Yeah, thank you very much. I just wanted to add to that too. It's just from not only the understanding with your auditor about what's all there, reviewing what all the municipality owns, but on top of that, there's some of these bylaws are citing the Urban Municipalities Act of 1984 and things like that. I encourage you to in some of these situations, blow off the dust and the cobwebs and take a look at some of the stuff. And a lot of times, you'll see that what the roles are of the municipality. And what the roles are of the rec board is. But not only that, maybe it's time to revise some of these things and adapt to new emerging issues or new structures and seeing what's all going on. It's one of those things where, if it ain't broke, don't need to fix it. But after a while, even, the best vehicles need maintenance from time to time. And just be sure to bring it in once in a while. And also about volunteers, just wanted to put in a plug again for the towns and villages with a population over 500. The session's on filling the volunteer void, and so I hope that you have the opportunity to go out there and they'll be talking about some of the things about interacting with volunteers as well and ensuring that they're meeting the needs of the municipality and that the municipality can treat them well too.
Great, thanks. Good comments, Stephen. On to microphone number 1.
I have no comments. I have no questions. I have just a quick comment. ML Whittles, Village of Kenniston. When you get together, I think it was Robert you're going to talk to about what the mayor's obligations are under conflict and that. When you give him the answer, could you send that out to all of us? Because,
Sure.
yeah, I've been told I'm just a counselor. I can't even make a phone call with everybody agreeing to it. And so it'd just be nice to know what, do I have a little bit of clout? And just on a personal note to SUMA, thank you very, very much for this. And it's a wonderful convention. And I'm really hoping that Mayor's School continues next year. I'll be the first one to register. Thank you.
Excellent. Thanks very much for the comments. And I know that's definitely for our staff, so appreciate very much the support that SUMA staff provide. Onto microphone 2.
Dwayne Light, Town of Kipling. My question is, if my employer has a bill that's up for approval of payment, do I need to declare a conflict of interest before proceeding?
Bill?
Okay, the legislation isn't that specific, but it is a matter that's involving your employer. You're asking the question, you've got some doubt, I would declare. I would declare on that.
So if we have several counselors who may have 2 or 3 bills, because we all have our own employers, so we could end up with 3 or 4 more motions just as people go in and out of conflict.
Well, and once you've declared it, though, you're good to go forward. So you only really have to declare it once unless something changes.
It has to be declared each and every time.
Each and every time. You have to go back to the document. You declare it.
You have to declare it at each meeting.
But
So
once
it's going to take a few extra motions at that meeting.
once it's on Form 1, though,
It's on Form 1, so really there's going to be no change, but they still need to declare that at the meeting when the bill comes up for payment.
right, but was the question that you have to go back and amend the form?
No.
Oh, I'm sorry, okay, I
No,
misunderstood
the question is, do I have to declare? Like, for example, I work for SAS Power. We're going to deal with that bill every month.
Stephen?
I'm gonna throw this out here too. It's one of those things that came up during discussion. Like number one of the things, as you've already kind of identified, that when there's bills that come due, you can stagger it in such a way so you're still able to, at least in the most timely manner, vote through things and just have people declare the conflicts as they go. But I think on a larger point here, and correct me if I'm wrong, anybody else on the panel. If you say you're going to make a payment, for instance, Sask Power, that's going to be an ongoing payment. Unless you really don't like power. I'm not sure. I don't think maybe is there some sort of like procedure or way that it just simply is something that's going to become due and payable, and would just be going ongoing as opposed to having to approve it every single time. Or what do you think about that, Phil?
Well, certainly the legislation is a lot more fluid than it once was. At one time, legislation did state something about bringing forward the list of accounts for approval to each meeting. Looking at the payment of, standard costs like power, something that could be delegated to administration. Right. So I'm not sure that they would, and it'd certainly be a discussion you'd want to have with the auditors as to how it's going to be recorded in the municipal records. I'm not sure that payment actually has to go forward for council approval each and every time. Legislation doesn't necessarily require that.
Okay, thank you.
Great, thanks very much. On to microphone number 1. We've got a line up there.
Jason Chineko, CAO, Town of Wynyard. I need some clarification from Phil for one thing, and then I'm going to try to advise you, Phil, to the best of my ability. When they talk about the non-disclosure statement, could you not go in camera for something until council needs to make a decision on something? But you wouldn't have to give up any of the details of what went on in a closed meeting on something like that until council needed to make a decision, or am I wrong on that?
Bill?
So you're going into closed session to discuss something that a member might have a conflict with?
No. I thought it was they were working with a company that wanted to sign a non-disclosure statement.
Oh, okay.
Yeah. So in a case like that, wouldn't that go for one of the 2 or 3 things that you can go into a closed meeting for? That's right in that sample bylaw that you guys sent out for the council procedures?
So we're going into the closed session to discuss the possibility of entering into a contract with them. And once
you enter, then there's no non-disclosure. I mean, if council is going in business with them, they would have to disclose it. There's no way against that.
That's exactly that. I agree with you on that. I don't know that non-disclosure is something that a municipality can actually agree to, because Section 117 gives people the right to take a look at those documents.
Yeah, but I'm just talking about the initial discussions. But anyway, the clarification I need is also on the non-disclosure statement. The way I interpreted the sample bylaw, it said to fill out the forms after as soon as possible after the general election. So, but you said something that led me to believe that they should have them filled out now, or do we wait till after the election in October?
Our understanding, Jason, is that they are applying to current members as well. Because they did have an election, but that provision wasn't in play at the time. Some municipalities did have public disclosure bylaws, and so they already had them in play. So our understanding of the legislation when it came into force is that that applied to current members as well, not just strictly the future members.
Okay, thanks.
Great, thanks very much. Again, microphone 1 and then 3.
Cindy Baumgartner, CAO with Village of Buena Vista. Back to the Sask Power bill paying. I have a counselor that works for Sask Power. He works for Sask Power. He's an employee. He has no gain by being there when we approve the power bill. Am I correct?
I wouldn't argue with that, no. But nevertheless, it's a matter involving his employer. So looking at the legislation very strictly, he's going to have to make that call.
Thank
but
you.
Again, as well, there's that perhaps administrative option to say these are fundamental contracts, so that you wouldn't have to be voting on every single time for certain matters.
Thanks, Stephen. Microphone 3.
Linda Dugan, Town of Mydale. Again, relating to the Sask Power employee, I believe I have the bylaw that states that I have the authority to pay all my utility bills without council resolution. I have a bylaw for that. So I don't have to wait till a meeting to do that. Would that not work?
I would see that as working, and then the motion might be simply to acknowledge the bills being paid.
Well,
there's no action being taken.
They get approved again because every check I write is shown to my council.
Sure, but again, if the bill's already paid, why would we ask for approval for that? So it might be 2 motions: one to acknowledge the bills that were paid, and then another one for that would authorize the payment of bills that we have not yet paid.
Right, but like this fellow then, should there be a record that says that he has a pecuniary interest in the check that I wrote last week for utilities? I'm confused.
And I understand. So that's why I think in that case, I would be inclined to have a resolution to acknowledge the payments that have been made. It's done deal. There's no decision. It's information that's filed. It could be, this is an administrator's report. I've paid these bills. You can't do anything about it, council. The check's gone.
Okay, then also now if I rewrote or amended the bylaw to state that I could pay my office caretaker, who also one of my council members' wives, which he has already declared on his disclosure statement? Or does do I have to give him a Form 3 every time I pay her?
You know, again, council has ability to delegate authorities to administration, to people. The intent of the legislation is really to have members of council declare conflicts when they exist. So if the member feels that he has a conflict, he's wise to declare. As opposed to trying the legislation doesn't get that fine. It says that if there's a conflict.
Right. But okay, so he declares it every month right now. It's declared that he had a pecuniary interest in the check written to his wife. That's in our minutes every month right now.
Okay.
But because of this page 3 of the disclosure statement, is that going to make a difference? Am I not going to be, or are we not going to be are we going to be still okay, or do we have to do something different now?
When the member declares a conflict, if there's no change to his public disclosure statement, he can write no change on it, sign it, date it, and give it to you. You stick it with with his other Form 1.
But every month he has to do that number 3.
According to the way the legislation is written right now, yes.
Okay, I had to clarify that.
Great, thank you.
And I guess one more question.
Sure.
What would be the reason if my mayor owns land in Alberta, does he have to put that on his statement?
No.
In Regina or just in Mydale?
In Mydale and in the surrounding RM.
Okay, thank you.
Great, thanks very much. On to microphone 2, then 4, and then 1. Go ahead,
Okay,
2.
two quick things. One is a comment for the town that was talking about the service or the groups that are running the baseball diamond and the rink and so on. We had that issue. Oh, by the way, Don Fornes, Mayor of Neville.
Thanks, Don.
Sorry about that. We had the same situation in Neville, went a little farther where the ball people stopped using the ball diamonds for years and years and years. Someone came in to try and buy the land, and we now have to go and chase people who are either dead or in old folks' homes, and nobody remembers who was even on the committee. So if you have these little volunteer groups, applaud them, let them go through your auditor for their budget or for their money that goes in and out. But for heaven's sakes, keep track of who these people are, because if you come back 10 years later and they're all in Winnipeg, you're going to have a heck of a time doing anything with the land legally. The second thing, and this is the process that we use, and you'll have to tell me whether we're going to have to change that with this conflict thing. What we do at each meeting is we go down the list of the appropriate bills that were paid from the month before, and if they include someone who is under contract to the village, even though they may have a counselor as a partner or whatever, do we not, like when we go down the list, unless we single out one specific payment for discussion, we just adopt them all and have a motion to pay all the bills. We don't single out anyone, and if we do single them out, that's when you declare. Is that proper, or are we out to lunch?
You would be doing it in a way that I think a lot of municipalities would, but the legislation, again, says that if that member has a conflict, should be pulling that one out and addressing it separately.
So then our responsibility is to pull it out?
Yes.
Okay, thank you.
In order to dot I's and cross T's.
Lots of little T's and I's, isn't there?
Thanks very much. On to microphone 4.
Good afternoon. Terry Dunn from the town of Kerrobert, council member. I guess one more comment on the gentleman from Sask Power. It was my understanding that if an item was of common benefit to the entire municipality, even though the person was involved, he is involved as an equal member in that municipality and does not need, in fact, to declare a conflict of interest. Can you comment on that, please?
I wish I had thought of that sooner. You're absolutely right. There are exceptions to conflict of to financial conflict of interest set out in subsection 2 of section 143, and that's Sask Power certainly would apply in that case. Again, I got focused on the employer side of it, and certainly a lot of these questions we were asked. Sask Power came up afterwards. And I just never got off that train track.
Okay.
Thank you very much.
Could I get actually two more, if I could?
Sure.
Along the same line, that if there is a contract in place and the price has not been amended and a bill comes up for payment, it is my understanding that a member may, in fact, declare a conflict, not vote, but remain in the room. Could you clarify that as well, please?
And that is correct as well. But there's still a requirement to declare.
Okay. And then the last one goes back to maybe a half hour ago to the gentleman who was asking about the property tax records. And this is just a comment, feel free to add to it, that perhaps the original intent of the legislation is to provide absolute proof positive that the municipality has attempted to contact the property owner to let them know that the property is in arrears of taxes, and they can point to the newspaper ad where they said, we published this on day X, and now we are taking the next step in the process to collect. It's not intended as a shaming operation at all. It is simply a legal way of being 100% sure you've made a legally correct way of contacting the individual concerned.
And as far as the intent of it, I can't speak to that. That's been in legislation forever, since at least 1980 when I first started as a municipal administrator. So, but that makes sense.
Thank you.
Excellent. Thanks very much. Going to go to microphone. I'm sorry, Stephen wanted to add a little bit to that.
And you know what? I just listened to these questions and seeing, I think, an incredible amount of goodwill with, these new, it's challenging rules, and you want to understand, and I absolutely applaud you. And I think that at the same time, too, I think there might be some really great opportunities for education as well. And I think that it would really, I see it as my part and my role with SUMA. But not only that, with Phil perhaps and some other folks, and seeing if we perhaps can continue getting some good materials out to everybody, particularly on not only what roles are and ways that you can work with this, but some of these other things regarding exceptions as well, and ensuring that people, because of course the golden rule is if you think you're in conflict, you probably are, but the corollary with that is no, and make sure. And I just absolutely applaud everyone here for coming out here and showing this good faith effort and wanting to do the best for their communities.
Thanks very much, Stephen. Appreciate that. We have 4 more people at the moment, and we have microphone 1, 2, and then 3. So microphone 1.
Jim Gallant, Mayor of Churchbridge. I have one question, and the other one's a comment. The one question is, why did they stop on the disclosure at your spouse and children? In a lot of these small towns, you can have your parents, your grandparents, your aunt and uncle own probably about half to 3/4 of the town. Why didn't you have to declare that part of that?
Laurent, do you want to tackle that one?
I think earlier I mentioned that the expectation initially in the draft legislation that was to go way outside the current list and include your extended family. And in negotiation and discussions with the province, it was brought back to the same extent as is applied to the members of Legislative Assembly. So it was narrowed down to a smaller group of people.
But if you had a grandfather that owned the hardware store and you were going to contract something out of that, wouldn't there be a conflict there?
So this is about disclosure.
Yeah.
Conflict could still exist, okay, even though you might be not within the scope of the disclosure, right? So it's trying to balance the protection of your privacy and the privacy of your family with public interest, but just because you're going outside what you've disclosed doesn't mean that there's no conflict. And I'll let the people from municipal advisors expand.
Certainly that's the case, and that's also where Form 3 comes into play. When you're declaring something in a meeting that's already enclosed in your Form 1, it seems kind of like a redundant step to have to say no change in Form 3. But when you're declaring a conflict because there's a perceived bias or it's something that's not within the scope as defined in the original statement, that's when it's going to come through in the Form 3. You're going to record it in Form 3 because you've declared that interest. And so it's, again, that balance between protecting somebody's privacy but also acknowledging if there's a conflict. If there's something going on where the municipality is involved in a decision that might affect somebody outside of the scope of the people that are disclosed in Form 1, the councillor may choose to disclose, and then it's going to go on Form 3 because it's pertinent to the matter at hand. But it doesn't mean that every council member is going to declare right on the outset everything that their grandfathers, cousins, etc. have, because it may not fall into that realm.
My other short comment is paying the bills. I could empty the council room real quick as soon as we get to the co-op bills because everybody's a member.
True. Laurent?
I think we all need to change our culture as well in terms of declaring a conflict is not a bad thing. Effectively, it is a good thing. It's to protect public interests. Very few decisions are that controversial that where your vote will count in the room to the extent that it will favor one side or the other. I've been in council chambers, and essentially declaring a conflict is a healthy thing for protecting public interests. And I think the message you're getting from the panel here is that it's not only real conflict that creates a problem, it's perceived conflict. And quite often, the right thing to do in saying, well, you know what, I'm a little bit too close to this one, and I'm going to step out, is not a bad thing, shouldn't be perceived by your colleagues on council as, oh, he's doing something or she's doing something wrong. It's really protecting and making sure as an elected official that you're protecting the public interest by no perception that your role in that decision could be perceived as tainting your own personal interests. And I think for too long we've heard about these things of conflict of interest. When real conflict of interest occur and they have not been dealt with properly at the council chambers, it's a problem. But when people disclose and step away from the decision, it's a healthy thing.
Thanks very much, Laurent. I'm just going to add one thing to that in Saskatchewan, there are no full-time councillors. We all have something else we do. So we are all potentially in a conflict. I'm going to move to microphone 2.
Samantha Gillis from the village of Sedley, and we have a locally owned store by board of directors.
I'll get you to move closer to the mic, please.
My understanding is that they do earn dividends, and when we pay that bill every month, I will lose quorum.
Actually, technically, you wouldn't lose quorum because if somebody declares a conflict, it doesn't affect your quorum.
But they have to leave the room.
Maybe repeat the question for us.
The quorum for purpose, okay, when members of council have a conflict of interest, you can go down to 2 people to still maintain quorum. Are you less than 2 people?
No, we wouldn't be. Okay, thank you.
Okay.
Section 146.
Microphone 2 and then 3.
Terry, I've been here a long time.
Sorry?
Which mic are you at?
Microphone 2,
Okay.
you were there, and then microphone 3, you will be next.
Okay,
he came up
Terry
right after you.
Korchinski, Town of Ituna. We have a situation where consistently our mayor tends not to bring forward communication that he receives on behalf of the mayor or the town. We have asked for letters to be presented at council table, and he refuses to do so. However, he did take the opportunity to reply in the paper to one of the letters that he received, which basically, didn't speak very highly of our town administrator or other council members. What process is there in place that we could ask to have communication? We have passed motions asking that any communication be presented around council table, refuses to do so. So where are we? What can we do to solve this situation?
Who wants to tackle that one? Bill?
No.
No? Get broad shoulders.
You know, the legislation does envision members of council working together. When members of council do not work together, when people are putting forward their own agendas ahead of everyone else's, it makes things very difficult. The council procedures bylaw, the council procedures bylaw, the code of ethics that's going to be coming down the pipe may help members of council deal with members who are not team players. But, you know, it's not necessarily going to change behavior. There's not any quick fix for solutions when people don't get along. Certainly there is ability in the Municipalities Act for members of council to curtail members of rogue members. There is ability to remove from each individual meeting of council a member who is misbehaving. In the case of people who have signing authority, the council can move to appoint different people for signing authority. They can remove people from committees. In some cases, in particular in the case of a mayor, I believe that a bylaw is going to be required in order to do that. While that legislation has existed since 2006, to our knowledge, no municipality has ever actually exercised that authority.
Okay, just a further comment. The new conflict of interest legislation that's in place, is there a start date as to when this conflict had to have occurred, or is it just during the term of this present council? How far back can you go? Like, we have a situation of absolute conflict of interest, but it happened prior to the legislation coming into place in November of 2000 and what is it, 15 or 14 when it came forward? After the Sherwood report.
Stephen?
November 19th, 2015 was when the new conflict of interest legislation came into force. Things that happened, whatever acts might be complained of that happened earlier than that would be under the pre-existing rules, and now everything that happens after November 19th, 2015 will be under the new rules.
So can you proceed against an action that happened in 2012 after the election?
3 years even under the older stuff. Yeah, even prior to the amendments, if a member was in conflict of interest and contravened the legislation, there was ability to go back for 3 years. That existed before November 19th.
Okay. Fine.
But you have to prove it to a court.
Okay, thank you.
Excellent, thanks. On to microphone 3.
Thank you. Excuse me, Brad Pattinson, Mayor, Resort Village of Goshen. I just think back to the Premier's words, none of us are in this for the money, but you wouldn't know that by this legislation or these disclosure forms. The Resort Village of Goshen being a resort community, there's 5 of us on council, 4 of us do some form of business with the village as members of the community, and we ain't in this for the money. In fact, most of the stuff we do, it ends up being cheaper, and we try to do as much as we can in-house. This will paralyze us. This will paralyze us because in those, and those of you that are in the resort communities know exactly what I'm talking about. You have a summertime population that wants everything and wants it, not when I say everything, they'd like, am I in your way? Okay. Oh, okay. There's folks that, you know, they're there, there's a 90-day season for construction, there's whatever the issues are, and council's expected to, you know, give approvals to permits to try to follow zoning by all that stuff, and I've talked to the advisory council about some of the issues. this, and I'm not saying this isn't needed. What I hear today is so many unanswered questions. The only way to get those answers is through time, through experience of trying to work out all of these what ifs. I'm asking today that the Advisory Council and SUMA, go back to the cabinet and go, hey, there's a lot of questions and a lot of valid things. Is like paying the power bill? Is that what we're down to now? We're worried about, geez, he works for Sask Power. I mean, it's crazy. It's almost overreach to me. It's almost overreach. And I know, I mean, I read the memo. It's the issue down here with Sherwood. I get it. I get that was blatant, hey. So, and just a couple other things I want to touch on. If I read the memos that come out, all of the boards that you folks talk about, the arena boards, the ball boards, they all have to sign these declarations as well. So, no, am I incorrect on that?
It's only the members of council that would be on those boards that would be signing it.
So you can serve as a committee and not disclose anything. It's interesting to me that somebody that, and I know where the mayor is coming from, one of the earliest questioners about the delinquent taxpayer. You're constantly going through the hoops that were put through to do tax enforcement. We can't put his name or hers, but I got to bare my soul. I hope that SUMA, I hope that all of you folks continue to go, wait a minute. In our case, there's 5 of us on our council, 4 of us have said we're not even signing it. I mean, people don't need to know all this stuff. I mean, if you're caught with your hand in a cookie jar, there's laws in place to put you in jail. Thank you.
Thank you. Sorry, Laurent, you wanted to comment on that?
Thank you. And based on these comments, you will remember that earlier in this session, I mentioned to you that we didn't feel that we could be immune in the municipal sector from conflict of interest legislation that would be clearer. We also said we should be immune to third-party oversight by the Ombudsman. But the part that I mentioned and I want to expand on is that SUMA was not in agreement with the way that this is rolling out. We have a SUMA convention today. In a few weeks, SARM is meeting. Later on this spring, UMass, the Urban Municipal Administrators, and later on, RMass, the Rural Municipal Administrators, are meeting. These are 4 major gatherings of municipal officials where these types of matters could have been discussed in the rollout. And ultimately, everybody who's interested in running again will take nomination papers in the fall. So our position as SUMA with the ministry has always been we could work through legislation, but we could also collaborate on the implementation phase of this. So where SUMA and the ministry kind of parted company was the way that this legislation is being rolled out, what we called in the 4th quarter of your game as elected officials. So we struggle with that, and we fully understand the comment that has been mentioned. And believe me, we've made the point quite clearly that we should take the proper time to roll this thing out in a way that everybody understands. Thanks.
Thanks very much, Laurent. Appreciate that. And I'm going to ask we only have 15 minutes and we have a hard stop at 4:45, and we still have 4 people. I'm going to ask you to really keep your preamble very short and just ask your question very quickly so our panel members can get your answer. We're on to microphone 1.
Chris Wyatt, City of Yorkton, Councillor. I would just urge all the people here, especially the elected ones, not to get too concerned about the conflict of interest papers that we're being asked to sign, because it's for transparency. And a lot of people are getting pretty worked up, and what you need to realize is, and I'll use the Sask Power employee, you work for Sask Power, but Sask Power is not giving you a bonus because you paid, the town or village paid the power bill. So really, there's no pecuniary interest for you just because you work for a very large corporation.
And I'm going to stop you there. Your question is?
Question is more, and it's more of a comment as well. The guys that are working for these communities, if you're doing the work, you just excuse yourself when they pay you as a contractor. And that contract should have been, isn't it going to be tendered out? So you wouldn't be part of the tender process. So there really is no conflict. So.
Okay, thanks very much. On to microphone 2, and then 3, and then 1. So, microphone 2.
Yes, hi there. Good afternoon. Bella Armistead from town of Radisson. I have a conflict of interest myself, and I just wanted to clarify, if I to excuse myself on the chamber, do I have the right to ask the decision right after the voting, when I excuse myself on the meeting?
To be informed of what the decision was?
Well, my property in Radisson, there's a caveat and an easement on my property that wasn't disclosed by the town way back before we even bought it. So now, on my property, there's a 10 feet by 137 long, and with the caveat and the easement, I'm not allowed to build anything on top of that property. So that it would be, my understanding, it would be a conflict of interest for me to bring that forward to the council. So do I have to wait for their decision if it's right after when I excuse myself on that chamber?
If it's a public meeting, that information will be available to you as well as anyone else immediately after the meeting.
Right after.
If it's a public meeting, yeah. That would be part of the record of the minutes, and that'd be available to anyone, including yourself.
Okay, thank you.
That's my take. Anyone else? Yeah. Disagree? Thanks. Okay, so we'll quickly move to microphone 3.
Can another councillor call out another councilman that he has a conflict if he hasn't declared it?
Can't tell you that until you tell us who you are.
Sorry?
I just need you to introduce yourself, please.
Oh, Terry Rowley, our
Thanks.
councillor, Resort Village of South Lake.
Hi, Terry. The legislation doesn't expressly state that you can call them out. However, members of council will have or may have a concern about a fellow member of council. So, yes, you're part of a team. Have a discussion. Have a discussion with them. That's not going to be in the minutes. If I'm still feeling that I don't have a conflict and I'm participating and you're still upset about it, raise a point of order. What shows up in the minutes afterwards is going to be very reflective of what happens. Either I leave or I don't. And if you're still very upset about it, ask for a recorded vote. You've got it on board that I'm there, I participated, and you can proceed with it afterwards. The council procedures bylaw too, build in a process there that you'll go through, what works for you locally. Because legislation doesn't set out the process for what you, as a member of council, will do if someone else has a conflict of interest.
Thank you.
Thanks very much. Our last question so far at microphone 1, please.
Pauline Chuka, Mayor of Esterhazy. Laurent, you said that, lost my train of thought, sorry. I'm just wondering if SUMA can't send us and our CAO some information that would make some of this a little bit clearer or a little bit easier, perhaps. Laurent, you had said something about all these other events coming up that are going to shed some light on this. Does that indicates to me that maybe we don't have to sign these immediately? Is there a deadline on that? And could you send us something just to clarify, like the SaskPower issue, for instance? We all have a list of accounts. We get paid once a month on the list of accounts. If we're not allowed to be in the room to approve it, who's going to?
I think we kind of did cover that, but...
Well, thank you. What I was expressing is the preferred route that we would have liked to see was to have had discussions here at SARM, at UMass, at RMass, before rolling that out and then implementing that as part of the next cycle of municipal elections. It didn't happen that way. Today, that is the law, and you must comply with it. So we're making attempts to clarify it by having this session, the 2 sessions yesterday, and by providing additional information. The ministry has put in a lot of effort, and there's your administrators should have received the package. Your administrators should have also received a link to a web page where some of these questions are answered. And the one from SaskPower is one I didn't hear before, but it's a good example of how complex this thing could be as we're trying to work through this new legislation. So I think I see Melissa has taken lots of notes here. I suspect that there would be another bulletin coming out of this providing some, and there were questions that were asked of Phil that he promised that he would come out with, clearer statements. So, no, we cannot delay. This is the way that it's rolling out. And yes, we're putting as much effort as we can to assist you working through the maze of the new legislation.
Great, thank you.
Great, thanks very much, Laurent. And just to remind everybody that next month sometime, all of these sessions will be on the YouTube channel. When you go to SUMA's site, you'll be able to get those. So if your administrator's not here and you think the administrator could have benefited from some of the conversation here, ask them to take a look at that. And vice versa, if you're an administrator and your counselors aren't here, another good chance to have that dialogue. So I do want to remind everyone that as you wrap up here at this point, to make sure you take all of your personal belongings so that the Everest staff here can reset the tables and get everything prepared. So big thank you very much to our board members that were here, and we have, thank you. We do have a gift, as we always do, for those folks that participate and assist us, and it's a scholarship contribution to the Mike Badham Scholarship Fund, who passed away, unbelievably, 10 years ago. 10 years ago. Hard to believe how fast time goes. But again, thanks very much, everybody, and I appreciate your involvement.